believe it, and I'm not going to hear you. I'm not going to hear you. I don't know what how do you not understand what I'm telling you? Now, if you've got that information and you think that's what it says, you get it to counsel and the court will take a look at it.
Get ready, this courtroom just went from 0-2 real quick. The judge not having the defense trying to explain. But what's really going down, you're about to witness a masterclass in courtroom control and a possible case of witness tampering unraveling in real time.
But I'm done. The court does call the case of the People versus Larry Lee.
Good afternoon, Your Honor. Marie Assistant Prosecuting Attorney on behalf of the people.
Have we got 2 minutes there?
And Mary Rubio, again, on behalf of Mr. Lee, who is making his way to the podium.
There's additional counsel that is on Zoom.
I'm sorry?
Oh, there you are.
Good afternoon, Your Honor. May it please this honorable court, Joseph Arabo on behalf of Stephen Kwasny.
All right. And I'm presuming everybody except the court has heard the phone call.
What I heard was the recording the prosecutor gave me, which appears to be a less than 2-minute portion of a phone call. I think she would agree it's not an entire phone call.
That's correct, Your Honor. It's what Mr. Rubble sent me, as well as Mr. Bird.
Partial evidence is still evidence, but in court context, is everything a 2-minute clip might hint at witness tampering or just miscommunication. But who controls the narrative? That's what makes or breaks this moment.
And law enforcement as of this morning.
All right. And that portion of the phone call, as the court is to understand, is basically this defendant speaking with, is it directly with the victim in this case?
No.
No,
The
Your Honor.
attorney.
It's with Mr. Rubble, who's the attorney for the victim.
All right. And basically offering to not provide testimony in another case if his client doesn't provide testimony in this criminal proceeding.
That is how I would characterize it, Your Honor. If Mr. Rubble has additional information or different information, he's welcome to.
Yes. Mr.
Yeah, just to clarify the record, that's a portion of a phone call because I didn't anticipate to record the entire thing. I didn't know who was calling me. And then once I realized what this was, which is an attempt to extort and use this other case that he filed against the victim in this matter to use as leverage to have this conversation at a future point in time, I was quick enough to get on my computer and record it so that the court is aware of what's going on.
Here's the twist: the victim's own lawyer becomes a recorder of potential witness tampering. That's rare. This isn't just he said, she said as he said. And I have the audio, but is it a smoking gun or just smoke?
And Mr. Kwasny, who's the victim in this matter, which is the first matter before the court.
Your Honor, if I may, I really object to that characterization that it was an attempt to extort. I've spoken to Mr. Lee at length about the purpose of the phone call. I also listened to the portion of the phone call. Perhaps the court could listen to it. I do not believe that was what was happening at all. And plus, I don't think there was nothing on there that indicated he was trying to extort this attorney or the complaining witness. Frankly, what Mr. Lee has alleged to me.
Now, the defense is flipping the script. No extortion, just frustration, miscommunication between lawyer and client is one thing. But calling the victim's lawyer directly, that's where legal ethics and criminal liability start to blur.
Have basically had a breakdown of communication, that he's spoken to Mr. Burgess multiple times, asking him to advocate on his behalf to the prosecutor as well as to this other attorney to try to come up with what he has called, not being a lawyer, using the words a settlement agreement or a plea negotiation. That's what he said to me. And that he had the feeling that Mr. Burgess had not, in fact, made this phone call. So he then called this attorney, and right in the phone call,
because it would have been unethical for Mr. Burgess to try to say my client won't testify in this other matter.
Of course.
If that, right? That's
well,
what Mr. Burgess may not have done.
And that may very well be. But Mr. Lee indicates that and I haven't seen these, he indicates that he has text messages back and forth with Mr. Burgess, and that Mr. Burgess, quote, lied to him about whether or not he made these phone calls. So he indicates the main reason that he wanted to call.
That would be irrelevant.
I know that, but Judge, trust me, I know that. But I just wanted to make a record. What, could I just finish though?
Let her finish.
Mr. Lee indicated the main purpose of the phone call was for him to find out whether this attorney could verify whether Mr. Burgess called him. If you listen to the call, the portion of this call, it's literally on there. He says, it starts out with him saying something about plea agreements. The call, it's interrupted, and I believe because counsel didn't realize he was going to need to record this. But anyway, it starts out with him, Mr. Lee, saying something about plea agreement, settlement agreement. Did Mr. Burgess call you to try to, see if I wouldn't testify and then your client wouldn't testify? Yes, he says that. But then he goes on to say, because my lawyer said he called you, and then this attorney confirms what Mr. Lee was trying to find out. And this attorney says, no. You see how easy it was to reach me. I didn't talk to anybody named Burgess. That's what he says. So I'm just indicating that Mr. Lee states that was the main purpose of his call, because he claims he wanted to come in here today and tell Your Honor that he did not want to have Mr. Burgess represent him anymore because he feels Mr. Burgess is lying to him. I'm just representing to you what Mr. Lee has told me.
I'd like to say something.
Thank you. Mr. Arabo, it's my turn. One moment. Your Honor.
Because apparently that's how it works in this courtroom. Tana says it's her turn, so it's her turn. Go ahead, Miss Tana.
Mr. Arabo had some trouble with the
That's only because she's there and I'm not.
I don't really, quite frankly, care what's going on with the client relationship with Mr. Burgess, or claims Mr. Arabo is making about extortion. That's not something that people are going to get involved in at this stage. What I'm concerned about is there is a clear difference between a plea negotiation and two witnesses not testifying, one of them being Mr. Lee, the other one being Mr. Crosby, not testifying in exchange for something. And I agree that the court should just listen to the call rather than us going around calling it different things. What's clear to me is that there is an offer to not testify in exchange for Mr. Crosby not testifying in this case for this court. That is what I'm hearing on that call. That is what's concerning to people, and that's what may bring future charges. We're in the early stages. This needs to go to law enforcement. It has gone to law enforcement now, and we can follow.
Your Honor, as you know, I'm a defense attorney. I think it's Ms. Rubio is really grasping at straws here to try to help her client. But here's what it is. It's not a plea. We heard her say plea. A plea means a reduction to something other than what he's being charged with, not a dismissal, which is clearly being indicated in this. Second, what's happened here is you could see clearly.
You can feel the prosecutor's frustration here. She's not just angry, she's shocked why. Because this might be the first time she's seen a victim turn into a defendant mid-case, allegedly as part of a strategy true it's courtroom chess at its most dangerous.
Between the clients, because in over 10 years of practicing, I've never seen something like this, where a victim turns into a defendant during a pending case. Never seen anything like this. So Mr. Lee has done this intentionally so that he can one day use it as leverage to contact me or have somebody else contact me or whoever is representing Mr. Kwasny so that he could use it as a negotiation tactic. And what he's engaged in is third-party communication to get through to Mr. Kwasny in violation of his bond. That's number one. He's got a no contact order. Second, this is witness tampering. You don't want to call it extortion. Let's find something else. It is witness tampering. He's trying to tamper with Mr. Kwasny using the leverage that he created. And I don't know if the prosecutor's office allowed this to happen. Somebody wasn't monitoring things properly, but this is what's happened. First ever time I've ever seen anything like this. And it needs to be handled. It needs to be handled. It's going to be handled.
Can we listen to the call?
Everybody listen to it.
Can somebody send it to Ms. Weidling, and I will then be more than happy to listen, or if there's an easier way for me to do it, I'll do it. Let's take the defendant back and we're to listen to the call.
You have to go back.
I'll handle that. I think Miss Atkins, so bring me. Court's going to stay in recess. Everybody can bring me. Pardon? Yeah. Yeah, bring those two back and then I'll.
He would like Miss Tana and Miss Kanguli on the Burns matter.
Laura. Yeah. Now I got Kennedy. Court does recall the case of the People's State of Michigan versus Larry Lee.
Good afternoon, Your Honor. Marie Tanhouse, Assistant Prosecuting Attorney on behalf of the people.
And Mary Rubio on behalf of Mr. Lee, who is approaching.
Clearly.
Okay. The issue is in this case that, first of all, we're adjourning the hearing.
I believe we are. That was what I thought we were doing in the beginning.
Well, it's got to stay before me. So.
I know Mr. Burgess is already going to be here on July 1st. I just wanted to put that out there.
Yes, but I'm not on the.
Oh.
I'm on the bench, but I'm not doing these.
Okay.
Set his preliminary examination July to defendant's request. So my next date is July 22nd, 2025, and that's another 12 p.m. start. Because God, I love that. All right. With reference to bond in this case, I've listened to the recording. I'm not going to say there's an over-exaggeration or an under-exaggeration. I mean, I think it's relatively clear when somebody's very clearly points out an exchange or quid pro quo regarding me not testifying and this other person not testifying, and that is the exchange. I don't know that you get a clearer indication of somebody that is attempting, and especially when they circumvent their attorney, of somebody trying to sort of tamper with and obstruct a case. It couldn't be clearer. I mean, and quite frankly, I don't think there's any design to necessarily frost it over or anything along those lines. I think the idea, or what Mr. Lee is saying about what Mr. Burgess wouldn't do, is quite frankly just a ruse to hide his own desire to have the exchange that he was speaking with counsel about. Given that, and the court having heard that, with reference to this case, the defendant's bond is hereby ordered revoked based upon the court's hearing of that bond violation.
Your Honor, can I just raise two issues? Before all of this happened, Mr. Lee expressed to me and attempted to express to the court his, as I'm sure the court has gleaned, his displeasure with Mr. Burgess. So I do think that, given some of Mr. Lee's allegations against Mr. Burgess, it may be best if someone else is appointed to the case. I know he doesn't want Mr. Burgess.
And that's fine. I don't know whether or not he doesn't want Mr. Burgess or not, because I think, as I'm indicating, I think that notion of Mr. Burgess not doing something and then his checking is simply a ruse for him to try to get the message that I want this quid pro quo, this exchange.
And I'm not accusing Mr. Burgess of anything. I'm just trying to represent what Mr. Lee has told
and I
me.
understand that.
And Mr. Lee
I
is
think
about jumping out of his skin trying to talk, just so you know.
And so when you talk to Mr. Burgess, if Mr. Burgess, if he believes that that's the appropriate step, he can bring that motion before this court, and the court will hear it in the day that I'm on. Mr. Lee, I will let you talk in a moment, but I'm going to finish this. Revoking your bond because of what is a clear violation of the bond regarding, I think it's an attempt to try to get indirect contact as well as obstruct these proceedings. Because that was accomplished in the manner it was, and I'm not sure that I can trust you with reference to no context and the like, we're at least going to get through this. I am going to, subject to a hearing, defendant phone privileges for the jail are also revoked. What did you wish to say, sir?
The thing that my substitute attorney here didn't convey to you was that I told her that I have the evidence with me in hand, that my attorney, Mr. Burgess, was the one that actually said that this was a legal way that we can go about it. And no, I'm not.
You know what, Mr.
I'm not-
Chairman, you might as well stop right now.
I have the text.
Because no, I'm gonna tell you, I don't know if you're misunderstanding something or what, but you are not, Mr. Burgess has appeared before this court. You are not gonna sit here and try to disparage that man, saying that somehow or another, Mr. Burgess represented to you that obstructing a case in this fashion was a legal way to proceed. I'm not gonna believe it, and I'm not gonna hear you. I'm not gonna hear you. I don't know what how do you not understand what I'm telling you? Now, if you've got that information and you think that's what it says, you get it to counsel and the court will take a look at it. But you're not gonna sit here and disparage that man. It is not gonna happen. I'm done. Bond revoked. Thank you.
Thank you, Your Honor.
Thank you, sir. Appreciate your wait and patience online.
No problem, Your Honor. Are you still on the record?
Pardon? I am.
Are you still on the record? I'm not sure who this kid is or what he's capable of or what sort of messages he can get out to other people. But if the court could put a no contact order because somehow I've become a witness in this matter, I'd appreciate that.
A no contact with you?
Yep. I don't want to be contacted by any third parties. I want out of this thing and I want to be done with it. Didn't ask to be here.
I will add that no contact provision. But counsel, why don't you let us know how you really feel? I know. All right. We'll take care of that.
I think the courtroom's been through enough today.
Contact.
Thank you. Appreciate it.
Thank you, sir.
Take care. Bye-bye.